Officer Davis, you open the courtroom for us.
The state of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning. Mesa Thompson. All right. Good morning.
Good morning.
We are on the record. This is case 23240-100. Mesa Thompson versus Beanstalk Real Estate. This is the second pretrial after this case, which was originally started in the Small Claims Division, was removed to General Civil. Could I have your appearance?
Good morning, Your Honor. Crystal Rappoon appearing on behalf of defendant Beanstalk Real Estate Solutions.
You remember the State Bar of Michigan?
I am.
You probably have a P number.
I do. P6170.
And what is your name, ma'am?
Mesa Thompson, appearing for myself.
Okay. We were last together on this file on April 18th. On that day, the court opened your written discovery. How's that coming?
I have no discovery to do, Your Honor. I actually went ahead and filed a motion for summary disposition and left a judge's copy as well with the court clerk.
Ms. Thompson, are you intending to do any written discovery?
I attempted to reach out to Crystal. There was really no solution. I have no idea. No,
that wasn't the question I asked you. I'm not asking about settlement discussions. I'm asking,
okay.
Were you planning to do any written discovery? She says she is not. If you are not, then I will schedule her motion for summary disposition.
Written discovery. I'm sorry, I'm not familiar with the term. Can you explain it to me?
It's your opportunity to learn about the claims and defenses of the other side. It includes such things as written questions to be answered under oath. They're called interrogatories, requests for production of documents and things, or requests for admissions. But you have to file and serve them in accordance with the Michigan court rules. Are you intending to do that or not, ma'am? I need to know.
Probably not. No.
Okay. Then I'll close your discovery. Counsel, you say you filed a motion for summary disposition?
I did.
When?
I just filed it yesterday.
Just yesterday.
Yeah.
You serve a copy on the other side?
I submitted it via mail. Yeah. Yes.
We have not received it, but that doesn't mean you didn't file it. But it also means that we can now get the 21 days in before our next scheduled hearing. All right, this is what I'm going to do. I'm going to close your written discovery since neither side is interested in doing it. I'm going to calendar for June the 13th, which is a Tuesday like today, June 13th at 10 o'clock, motion for summary disposition filed on behalf of defendant Beanstalk. Does that date and time work for everybody?
I believe so.
Okay.
I'm looking. I'm sorry, what time did you say, Your Honor?
10 o'clock like today.
Absolutely, yes, that works for me.
Okay, works for everybody. We'll send out a notice. June 13th at 10 o'clock, motion for summary disposition on behalf of defendant. Your written discovery is now closed. Thank you all for coming in. We're off the record.
Thank you.
Mr. Burke. On the road again, I see.
Yes, sir. Parked, though.
Well, that's good. All right,
Yes.
we are on the record. This is case 23-142800, Beaumont Health versus Kenneth Thomas. Could I have your appearance for pretrial?
Thank you, Your Honor. Hal Burke, P69068, attorney for Beaumont Health on this case.
And what is your name, sir?
Kenneth Thomas.
All right. Before we go any further, I want to read into the record an email that the court sent today in response to an email that was sent to me by a Cassandra Thomas concerning this case, was signed by Mr. Thomas.
Yes.
Email begins, Mr. Thomas, I have deleted without reading your email. This is a totally unacceptable ex parte communication by a litigant with the court. In the future, do not email anything to this email address. If you feel the need to communicate with the court, you may do so at a regularly scheduled pretrial conference or by properly filing and serving a motion on both the court and opposing counsel. Any email filings shall be done using the 36th District Court portal. Then, and this is in all caps because this is serious, sir, I want you to understand this.
Okay.
Any further attempts at ex parte communication with the court may result in sanctions, including default judgment. My signature. You may not have an ex parte communication with me. The other side is entitled to be present for any discussions, any communications concerning this case.
Okay.
Where are we, gentlemen?
I
Your
did
Honor,
also,
Your Honor,
I'm sorry, Mr. Thomas, what do you want to say?
I said I did also send the attorney the same thing as well.
Okay, if you, again, you may not communicate with the court ex parte.
Okay.
Where are we on this thing?
Your Honor, I also received that email and I will attempt to try to review it. I did get it today, right before the court hearing. So I think it's his attempt for discovery, and without giving him legal advice, I'm happy to review it. However, probably it should have been filed in a motion. He denied everything again, kind of like his written answer. My request is maybe we just need a trial date on this case if Mr. Thomas believes he does not owe anything.
Mr. Thomas, do you intend to do any more written discovery in this case?
No, sir.
How about you, Mr. Burke? Are you intending to do any written discovery?
No, Your Honor.
All right, well, this is what I'm going to do. I'm going to close your written discovery. And as I indicated, I did not read your email. I just noticed there's an ex parte communication. And so what I'm going to do is I'm going to give you gentlemen a return date. And that date will be June 13th at 10 o'clock. If you have not resolved your case by that time, then if anybody plans to file dispositive motion, you should get that motion filed by that date, not to be heard, but filed by that date. Is there anything else we can accomplish today?
Nothing
No.
from the plaintiff, Your Honor. No.
Anything for you, sir?
No, sir.
June 13th is 10 o'clock. Your written discovery will close on June the 10th. Thank you, gentlemen, for coming in. We're off the record.
Have a
Thank
great day. Thank you.
Frequent flyer, Andres Nelsons, who is the music director of both the Boston Symphony Orchestra and the Leipzig Gewandhaus Orchestra for most of the month of May. He's in Leipzig with that band, and then he's back in the summer at the Tanglewood Festival in Lenox, Massachusetts, where he'll return for his conducting for the Boston Symphony Orchestra for a good part of the summer. And then once the fall season starts again, back before he goes between Boston and Leipzig. That's Andres Nelsons with the Vienna Philharmonic playing Beethoven's First Symphony on WRCJ 90.9 FM. Support for WRCJ is provided by the Detroit chapter of the American Guild of Organists. It's been called the King of Instruments, and Beethoven called organists the greatest of all virtuosos. The AGO is a national organization, and the Detroit chapter is one of the largest in the country, first founded in 1910. Information is available at DetroitAGO.org. 90.9 Detroit, Windsor, Ann Arbor, non-stop classical music all day long. Enjoy the inspiration and companionship with great music continuously. Just tell your smart speaker to play WRCJ. Third calls. Music by Sean Philly Rameau for the keyboard, played on his piano keyboard, Christopher O'Reilly for the music by Rameau, WRCJFM. Portorino Respighi up next. He wrote music about the birds. It's the name of one of his orchestral suites. Here's yet another that borrows the music of Rossini in Magic Toy Shop. Gian Andrea Noceda and BBC Philharmonic.
All right,
Good morning.
good morning. This is case number 23-141460. JH Liquidating Trust 1 versus Leah Hawkins. Could I have your respective appearances?
Good morning, Your Honor. Jim McCarroll appearing on behalf of the plaintiff.
You remember the State Bar of Michigan?
I am, Your Honor.
Then you probably have a P number.
I do.
Care to share?
82443.
Your appearance. Mr.
Yes, for the record, Sanford Melder, P23604, representing defendant, Your Honor.
Okay, guys, I opened your written discovery on this file back at the end of April. What has been done? This is our first pretrial on this case.
Your Honor, if I may speak, and normally I know I'm out of turn, but there's a couple of things going on. First of all, as to discovery, my client in pro per got a SD motion mailed to her 4 or 5 days ago. She got it to me this morning. I don't understand. They have an answer because they listed in the SD motion, but they don't acknowledge me in any way being her attorney, and I have not received a copy. More importantly, this case has been already resolved. In 2018, another attorney, O'Cease and Weber, filed case number 181-61364 in front of this court regarding this very same debt, and a satisfaction of judgment was filed in that case. I called defendant attorney yesterday. I spoke to one of his associates. I explained all that. They said, well, somebody will get back to you. I never heard a thing after that.
Mr. McCardle?
Well, first of all, insofar as the motion for summary, I'd be happy to get a copy of that over to council. That was my mistake. It was simply, I overlooked it. Now, the second thing, as far as the prior payment, I just for everybody's benefit, I have a mediation starting in a minute. I will be happy to contact Mr. Melder after I'm done with my mediation so that we can exchange information as to the prior payment allegation. I'm looking in my notes now, and I see that there was a phone call. No one notified me about the phone call, so this is news to me, although I do see that there was a conversation yesterday. So if it's okay with Mr. Melder, I'll be happy to call him once I'm done with my mediation, and we can discuss how to address that issue.
All right, gentlemen, this is what I'm going to do. I'm going to give you a return date, June 13th at 11 o'clock. Your written discovery remains open. And you guys get together and let's figure out what's going on this file.
I'll be happy to do so, Your Honor. Mr. Melder, are you going to be available in perhaps at about noon?
Yes, 248-541-3400.
Mr. Melder.
Yes, sir.
Internet. Do you really think everybody in the world needs your phone number?
Well, maybe it'll promote some business, Judge.
Never thought of that. Okay, guys, June 13th at 11 o'clock, your written discovery continues. Thanks for coming in.
Thank you, Judge.
Mr. Melder.
Thank you, Your Honor.
Let's be safe.
Thank you. I'll wait for your call, sir.
I will give it to you and give you a call as soon as I get done with this mediation.
Bye-bye.
Bye-bye.
Where's my, here it is. Here's our whole name. Yes, you will. Case number. Mr. Moon.
Good morning.
Good morning. Who are you representing today?
I'm here on, I represent, We Transport, versus City of Detroit.
Okay, I got
okay.
the other side, so I think we're ready to go.
Okay, great.
Oh, Judge Ryan.
Good morning. All right, this is file number 22-198-271. WE Transport LLC versus City of Detroit. Could I have your appearances, please?
Good morning, Your Honor. Ibrahim Hamoud on behalf of plaintiff.
You remember the State Bar of Michigan?
I do, Your Honor. 75765.
Your Honor, Jesse Halpern on behalf of the City of Detroit, B66936.
All right, how are we coming, gentlemen? This is our second pretrial. How are we coming on service on our other defendants?
Your Honor, yes, we did recently add a new defendant. We filed our amended complaint with the court, and it was received on April 24th. We didn't get a stamped copy back from the court yet, so we're going to be following up on that, making sure we get it, get a new summons and serve the parties.
Okay, well, we can't do anything else today then. Let's see you guys again next June 13th, June 13th at 11. Does that work for everybody?
It does, Your Honor.
Yes, Your Honor.
Okay, we'll see you then. No point in taking your time up. Let's get done, things done. Thanks for coming in. We're off the record. June 13th, 11 o'clock.
Great, thank you. Have a great day.
Thank you. You too, sir. Mr. Rusin?
Judge, how are you today?
I'm good. And yourself?
Not too bad. I had to instruct my staff yesterday that the chief judge of the Wayne County Circuit Court takes settlement conferences very, 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 very seriously. But he has a constant parade of them on settlement day, and it's unbelievable. I'll tell you that sometime when we're back in court. But anyways, here we are today.
Well, I'm waiting for Ms. Mitchell to join. She checked in a moment ago, so maybe she can come in here. We can get started on your file.
All right. Well, we'll see what's going on.
Did you get your case settled? No, she went away.
Well, I was a dead last one, of course. So at least I have a friend in the judge's clerk, so he was very apologetic. The judge was apologetic, but when you get up there in the circuit court, their settlement conferences are like for the big high profile cases. So and the new chief judge is Brian Sullivan, who used to work for the Michigan Supreme Court, and he's very interested, according to his own words, to quote, do the right thing and to have a well reasoned opinion. But that's just Brian Sullivan. He gets very active up there in settling cases on the settlement conference days, and he also has a habit of, if there's a new attorney that says the wrong thing,
He has a bad day, huh?
which yesterday was some P80,000 attorney, and the attorney couldn't hear the judge. He says, "Come again," and Judge Sullivan goes, "Come again? I haven't come anywhere." Come again is what you say in a football game. You don't say that in court.
Joys of circuit court.
Yeah,
I'm gonna put you back in the waiting room. Ms. Mitchell seems to have disappeared.
that is just fine. I'm doing chamber work, so I'm ready when you are, Judge.
Okay, back to the waiting room. Nicole G. Morning, Council.
Good morning. How are you?
I'm not bad. How about yourself?
Hanging in there.
What file you here today?
I just learned that one of my clients in Judge Sabri's landlord tenant, excuse me, case has a file before you, 231-46008.
And so you're appearing on behalf of whom?
I'm willing to appear on behalf of Mercedes Taylor. I just found out about this case this morning. I'm assuming that this is a pretrial, so we'll be setting it for hearing. It's a messy one.
It is a pretrial. I don't seem to have your opponent as of yet. So I'll put you back.
Is Ms. Taylor here?
Yes, you want to talk to her?
If you have breakout rooms, that would be great.
Yeah, okay. Let me get here and I'll put you guys in the breakout room.
Thank you so much. There's another woman coming that's been working with her too.
What is that?
Her name is it's Tamika K. So if she comes, okay. So if she comes, you can put her in with us too.
All right, when Ms. Taylor connects, I'll put you guys in the waiting room. Into a chat room, excuse me, soon action.
Perfect.
Ms. Taylor?
Yes, I'm here.
All right, I've got your console here, so I'm gonna put you guys into a chat room.
Okay.
Hello? Hello? Hello?
Hello,
What is your name?
Linda Gadsden.
All right. All right, I'm gonna put you back in the waiting room. Counsel and her client are having a conversation. We'll get to you soon.
Thank you, sir.
Yes, ma'am. Hello? 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 What is your name? What is your name, ma'am?
Oh, hi, Your Honor. I'm Tamika Keithley.
Tamika.
I'm here for Mercedes Taylor.
Oh. Okay, hang on. They're in the chat room. Let me see if I can get you in there.
Please, thank you.
And let them know that I have the defendant whenever they're ready to go.
Okay, thank you.
6. Hello?
Hello,
What is your name?
Tamara Mitchell.
All right, hold on. I got the other side. We can get started finally. All right, we seem to have everyone here. This is file number 231419110. LVNV funding versus Tamara Mitchell. Could I have your appearance?
Judge, may it please the court, I'm Attorney Richard Roos. My bar number is 35222. I'm the attorney of record for plaintiff. And I am also the appearing attorney on behalf of plaintiff in this pretrial.
And your name, ma'am?
Tamara Mitchell.
Okay, this is our second pretrial. When we were together on April 18th, the court opened your written discovery. Where are we on that?
Judge, I can tell you that I served by first class mail written discovery on Miss Mitchell that went out of my office May 1 based on the proof of service. Defendant's still within the time to file answers to that written discovery. And so that is where we are at the moment.
All right. Ms. Mitchell, are you intending to do any written discovery of your own?
No, I just received that written discovery on May the 8th.
Yeah, that's not my question. My question is,
Oh, I'm sorry.
are you intending to send out any written discovery?
No, sir.
Okay, then let's get his answer and we'll get you guys back here on the 13th of June, June 13th at 11 o'clock. Does that work for everyone?
Yes, Judge.
Okay. One question. By me not doing the question that you just asked me, not doing a written discovery, that's what postpones the court date to another day.
I don't understand what you're saying, ma'am. I'm giving you, we have a schedule
Okay.
and I'm keeping the schedule. You have time to answer his dates, his discovery. You don't plan to do any of that, you're right. But you still have to answer his. And so you're not at late overdue on it. So we'll give you time to answer it. That's all. So
Okay.
June 13th, 11 o'clock. We'll see you then. Your written discovery will remain open. Is there anything else we can accomplish today?
No, at this time, plain for us, Judge.
Anything for you, ma'am?
No, sir.
Okay. Thank you both for coming in. Let's be safe out there.
Thank you, Judge.
Okay. Thank you.
Yes, ma'am. We're off the record.
Okay. Bye-bye.
Bye-bye. Mr.
Hi,
Lynch,
Judge. How are you?
I'm not bad. How about yourself?
Pretty good.
I don't have your opponent as of yet. I just want to let you know I knew you were here.
Okay. Okay. You want me to give him a call?
Yeah, you might as well. Put you back
Okay.
away.
Yeah, I'll do that.
Thank you.
All right. Yep.
All right, Ms. Lamont, are you ready to proceed?
I am ready to proceed, Your Honor.
All right, I have your opponent. What I'm going to do is I'm going to mute Ms. Taylor and the other lady who are here.
Okay.
Since you are here as counsel.
Terrific.
Taylor, let me get the other lady in here. Let's get started. All right. We are on the record. This is file number 23146-008, Mercedes Taylor versus Linda Gatson. Could I have your appearances, please?
Suzanne Stepich Luan, P48702, Michigan Legal Services, on behalf of the plaintiff Mercedes Taylor.
I'm sorry.
I will be
counsel.
filing a formal appearance in this case later today.
Give me your P number again, please.
48702.
Got it. And what is your name, ma'am?
Linda Gadsden.
Ms. Gatson, is it your intention to represent yourself in this matter?
Yes, sir.
You have an absolute constitutional right to do that. What you do not have is a right to your own set of rules of civil procedure, your own rules of evidence, your own statutes. If you elect to represent yourself, as is your constitutional right, the same rules that are binding on counsel are binding on you. Do you understand that?
Yes, sir.
All right, what is this claim about, counsel?
This claim is about possession of a home. The home was purchased by a nonprofit organization that was formed with Ms. Gadsden as one of the directors, I believe in 2016. It was dissolved in 2020. The purpose of this nonprofit corporation, according to their articles of incorporation, was to help with neighborhood blight and to help families. And they purchased a home through the Detroit Land Bank, which they then sold to Ms. Taylor for $1,000 under the with the agreement that Ms. Taylor would complete the necessary repairs on the home to bring it into compliance with the land bank. These improvements and repairs were made. We have the notification of compliance from the land bank that was sent to Ms. Taylor. And Ms. Gadsden and Familyhood received the deed to the home. They then refused to transfer it to Ms. Taylor, claiming that
let's
there
stop
were.
right there.
I'm sorry.
I didn't understand Ms. Gadsden and Familyhood. What is that?
Familyhood is the nonprofit corporation that technically owns the house.
And they got the title from the Detroit Land Bank.
They got the title from the Detroit Land Bank. The
Please
agreement
continue.
with, I'm sorry?
Please continue.
The agreement with Familyhood through Ms. Gadsden as their representative was that they sold the home to Ms. Taylor. She has been working on this home since Familyhood purchased it in 2018, I believe. I'm sorry, I just looked at the file, but my dates are swimming. I have it all. But the agreement, and we have a letter from Familyhood with Ms. Gadsden's name on it, saying that they will sell they sold the property to her for $1,000. And in return, she was to make the repairs to bring it in compliance with the land bank. The understanding was that then once it was in compliance with the land bank, the deed would be transferred to Ms. Taylor. Once the repairs were completed, Ms. Gadsden and Familyhood then refused to transfer the deed, stating that there were unpaid water bills and unpaid taxes. Ms. K and myself, well, not myself, I wasn't involved, but United Community Housing Foundation, Michigan Legal Services, and Ms. K have been trying to work with Ms. Taylor. She qualifies for assistance in many of these bills, the taxes, which she has been paying, the water bill, which she has paid some, but she qualifies for assistance to them, but that cannot be given to her until the bills are in her name. And Ms. Gadsden has told her that she will not transfer the bills to her name so that Ms. Taylor can get them paid. And that she won't transfer the deed to the home until these bills are paid.
Ms. Gadsden,
Yes, sir.
what's going on here? What's your side of this?
What's going on here, sir, is that the agreement with Miss Taylor in 2018 was that, number one, the land bank requires repairs to be completed in 6 months, with extensions being allowed when justified. At the time that the property was agreed to with Miss Taylor, she understood that she was responsible for the property taxes and the water bill. Miss Taylor has not been paying the water bill because the water bill is, as of today, for $5,000. The property taxes, Miss Taylor paid on one occasion, but as of this year, Wayne County was scheduled to take that house for failure to pay property taxes. In 2020, the land bank contacted me to ask why the house was not in compliance and what needed to happen. I sent the land bank a letter that Miss Taylor also received a copy of, and asked Miss Taylor to complete what needed to be done within 60 days. Within 60 days, the land bank did release the property. However, the property taxes were past due and the water bill was past due. Miss Taylor has made only one payment on her water bill since she requested moving in 2018. Miss Taylor knew when she moved in, she was responsible for the water bill. She paid the security deposit. In 2020, the water bill was only $230 because Ms. Taylor had not been showing usage, although she had been in that house for over 2 years. At that point, Ms. Taylor verbalized that she would not pay another security deposit to the water company in order to get the water bill in her name. I have nothing to do with the water company requiring a security deposit. In January of this year, last year, in August, I sent Miss Taylor a letter noting to her that the property taxes were past due and that the water bill at that point was $2,000, and that she needed to resolve that or the house would be sold in order to cover those debts that she acquired while living in that residence. I have seen, Your Honor, Wayne County take a property back, sell a property, and still come to the original person for past due property taxes. And therefore, I do not care to be faced with that 5 years from now. So yes, I put a payment arrangement on the property taxes to prevent foreclosure. That is why Miss Taylor is before you now, because if Miss Taylor thought that I was doing something to her that was unacceptable, she has had 5 years in order to come forward.
All right. Ms. Luan.
Your Honor, yes, if I may respond to a couple of those
Well, let's
things.
stop right here.
Okay,
My first question is whether you and Ms. Gadsden have had an opportunity to converse.
we have not, because I only learned of this hearing an hour ago.
All right. This is what
I will say,
This is what I'm going to do.
okay,
I'm going to adjourn today's hearing until June 13th at 11 o'clock. I will look forward, Ms. Lewan, to your formal appearance being filed in this matter. Ms. Gadsden, does the nonprofit have a lawyer to represent it?
As a result of COVID, the nonprofit has fallen apart.
Okay, so the
That
answer
is
to my
not-
question is no.
Yes.
All right, so you will continue then. Ms. Lewan, what did you want to say?
I was gonna say, but the property is still held by the nonprofit.
Well,
No, sir.
I understand that.
Yeah.
But that's a different issue. At this point, what I'm trying to do is get the parties properly aligned. And then my other question, Ms. Lewan, is why are you here? As you know, the district court does not have equitable jurisdiction. Sounds to me, this is a title dispute, which belongs in the circuit court, not here.
And that is exactly what once I found out that this claim had been filed, I began representing Ms. Taylor in an eviction proceeding by Ms. Gadsden's granddaughter to get her out of this home. So I am representing her in 36th District court on that eviction proceeding as well. I learned about this morning, and both Ms. Kay and Ms. Taylor and I have discussed that this really, the proper action is to be a quiet title action in the circuit court.
All right, I'm going to give you a June 13th, 11 o'clock return date. I do
Okay.
not expect to see you on that date.
Yes, Your
By
Honor.
that time, I want this matter dismissed and your matter commenced where it's supposed to be, in the circuit court.
And that will happen, Your Honor.
Okay?
Thank you.
Let's everybody be safe, and thank you all for coming in.
You too, and I have to compliment you on how you maintain your courtroom. We've had a lot of interesting photographs portrayed over other courtrooms.
Thanks for coming in.
Thank you.
Thank you, Your Honor.
All
Ms.
right,
Taylor,
y'all
Ms. Kay, I will give you a call, and Ms. Gadsden, we will be in touch.
Y'all be safe.
Thank you
too.
as well.
Thank you. Bye.
All right, oh, wait, Mr. Lynch, hang on, let me see, I have somebody here, I don't know why he's here. I have some
Okay.
lawyer here, let's see if he's here on your case.
Anthony Adams is,
Oh, okay, then it is.
yep, that's him.
Yeah, I was about to. All right, this is file number 23-145-141. This case is entitled KSI Holdings versus Anthony Adams. Excuse me, Anthony Adams is the attorney. Rodney Jenkins, DBA Construction Services, is the defendant. This is our first pretrial. Could I have your appearances, please?
Good morning, Your Honor. Stephen Lynch, P70211. I am appearing for the plaintiff in this matter.
Anthony Adams, P 33695, appearing on behalf of Mr. Jenkins.
Mr. Adams, pull over, please. I do not want to be part of an accident. Let me know when you have stopped.
I have stopped.
All right, gentlemen, what's our dispute here?
This is goods sold to the defendant for some, I think, home repairs. He is disputing that one of the charges is not his. It was actually a customer that made the charge. We have been trying to settle it, and there has been an offer back and forth. I think I'm currently waiting on the answer to my counter offer, but this should be resolved pretty shortly.
Okay, then what I'll do then, gentlemen, is I'll continue your written discovery. I'll see you again June 13th at 11 o'clock. Does that date and time work for everybody?
Yes, sir.
Sorry. Yes, Your Honor, that works for me.
Okay, well, let's get this one done, gentlemen. Doesn't sound like this is a hard one. Thank you for coming.
No, it's not. Thank you.
Mr.
Thank
Adams,
you,
be
Your Honor.
safe. We got
All right,
to get
bye-bye.
back on the road.
Yeah, I'm heading to the airport. Bye-bye.
Be safe, gentlemen. Thanks for
Right,
coming.
thanks.
Bye-bye. The next file we're going to call is file number 222000299. The file is entitled Stephen Rubin versus G&C Personal Touch Home and Commercial Improvements, Inc. and Lloyd Taylor. By a notice dated April 20, 2023, and sent to the parties on that date. This matter is set for pretrial today, May 16th at 11 o'clock. It is now 11:37. Neither party having appeared, the matter is dismissed without prejudice. I note for the record that notice of today's pretrial is mailed to Kendall Saylor and to Roman Chikali, listed attorneys for the respective parties. Case is dismissed without prejudice, neither party having appeared. The next file we're going to call is file number 23240-024. The defendant in this case is UDHC Metro Sierra Funding. There is no way I can pronounce the name of the plaintiff, so I will spell it. First name, ONYEMAUCHE. Second name, CHUKWEKE. In any event, by a notice dated April 20, 2023, and mailed to the parties on that date, the named plaintiff and attorney Ted Phillips for the defendant. This matter is set for pretrial today, May 16th at 11 o'clock. It's now 11:37. Neither party having appeared. This matter dismissed without prejudice.